Miss Nancy, our clerk, to come up from the clerk's office.
No problem. Thank you.
Thanks for giving us the additional time today, Your Honor. We were able to get a judgment circulated.
Absolutely. The court appreciates the efforts of both of you.
You might not like us much later today, but we're okay for now.
Right.
Okay. Do you want to meet with the front of the court this afternoon?
That's fine. I figured you'd probably have us do that.
Yeah, that's fine
I
with
don't know
me.
if it's necessary, and I'll leave it to the two of you.
It can't hurt. We'll see what we can do for a few minutes. If it looks like it's not going anywhere, then we can end it and just see you at that point.
Okay.
There's now a session, Derek Duschl versus Molly Duschl.
For the record, this matter is before the court for continued pretrial conference. Subsequent to the parties having engaged in mediation with Ms. Pratt in front of the court this morning, this hearing is being conducted via Zoom. To his attorney, materials representing the plaintiff, Derek Duschl, and Mr. Duschl is present. In addition, attorney Kimberly Kuhn is present, representing the plaintiff, Molly Duschl. Ms. Duschl is present with Ms. Kuhn. The court has been informed the parties have reached joint agreement. Is that correct, Ms. Sills?
Yes, it is, Your Honor.
Right, Your Honor.
Who'd like to place agreement on the record?
I'll do that.
Please.
Your Honor, the parties have agreed that spousal support would be barred as to both of them. We would include standard statutory language regarding life insurance. Each party would be awarded all pension and retirement benefits in his or her own name. The parties do own a home together. That home is currently under contract for sale. The closing is scheduled in a couple of weeks. Pending the closing on the home, the parties are going to own the home as tenants in common and would equally split the mortgage payment, utilities, insurance, and taxes on the home. Should that sale not close, for whatever reason, we're not anticipating any issues, but should it not close, the parties would continue to agree as to the listing agent, the listing price, any price adjustments, and the final sale price. They would also follow the reasonable recommendations of the realtor. Any refunds for escrows, utility overpayments, or any other sorts of refunds related to the sale of the marital home would be split equally between the parties. The Toledo Firefighters Federal Credit Union loan ending in 4500 and the approximate amount of $7,058 would be paid in full from the proceeds of the sale of the marital home, and the parties would equally split the remaining net proceeds from the sale of the home after that debt is paid in full. With regard to personal property, each party is going to be responsible for the debt owing on the personal property awarded to him or her and hold the other party harmless from liability for that debt. Mr. Duschl is awarded the 2018 Ford Escape and the 2003 Harley-Davidson motorcycle. He is going to, again, assume the debt on that vehicle and hold her harmless. He is also awarded the cast iron pans that the parties own, his premarital property, including his guns, lawn equipment, and his personal effects. Ms. Duschl is awarded the 2012 Honda Civic, again, with the standard hold harmless language. And she is also awarded all of her premarital property and all other property not specifically awarded, as I had just stated, to Mr. Duschl, including the contents of the marital home other than the cast iron pans. Parties are going to divide their joint Huntington Bank savings account, and the account will be closed when Ms. Duschl's paycheck auto deposit into that account is diverted to her separate account. After April 4, 2020, after today, any of her paycheck auto deposits into that Huntington joint savings account would be considered her separate funds. And the parties are going to equally divide the Huntington joint checking account. Only the necessary expenses will be taken out of the joint checking account pending its division. The parties are going to maintain the status quo as to deposits into the joint Huntington Bank checking account until April 30th, 2024, at which time we would expect that the auto debit and auto deposits would have been terminated by the parties coming to and from that account. That account is going to be closed at the later of April 30th, 2024, or when the marital income tax refunds, both state and federal, are received. Those are scheduled to be auto deposited into that joint Huntington checking account. Mr. Duschl is awarded the joint Toledo Firefighters Credit Union account in he is awarded the joint Toledo Firefighters Credit Union account and the proceeds of that account. And Ms. Duschl is going to take all necessary steps to remove her name from that account. Each party is awarded all of the bank and financial accounts that are solely in his or her own name. Parties will sign whatever is necessary, take whatever actions are necessary to effectuate the terms of the settlement agreement. With regard to marital debt, each party is going to be solely responsible for what's in his or her own name. And the only joint debts that I'm aware of are the Toledo Firefighters Credit Union loan, which I referred to in the real estate section, which will be paid off with the sale proceeds, and the mortgage, which will also be taken care of with the sale. Parties would acknowledge not having received any tax advice from their respective counsel. Ms. Duschl's maiden name, and I'm not sure how to pronounce it, I'm sorry, it's Skowronek, may be restored to her if she wishes. Each party would be responsible for his or her own attorney fees. Each party warrants that they have disclosed all of their assets and liabilities in the course of negotiations of this case. And I believe that is the entire agreement.
Thank you, Ms. Hills. Ms. Kuhn, did Ms. Hills accurately state your client's agreement?
She did, and just for clarification for the court, Your Honor, the Harley Davidson that was awarded to plaintiff is paid in full, so there's no loans on that. So I just wanted to let you know that. And then we're going to keep the joint checking account open. They're going to equally share in any tax refunds, any of the tax refunds for 2023. So the account's going to stay open so that once those are deposited, they can just equally split them. So just clarification, but no, Ms. Hills did state it accurate.
That is all correct.
Right, thank you. Mr. and Mrs. Duschl, can you both please raise your right hand to be sworn?
Yes, Your Honor.
Yes, Your Honor.
Ms. Duschl?
Yes, Your Honor.
Ms. Duschl? Okay, there you go. You just need to speak up so the court can capture your responses. Ms. Hills, you can begin with Mr. Duschl, please.
Yes, Mr. Duschl, you can lower your hand. Would you state your full name for the record, please?
Derek Xavier Duschl.
And you are the plaintiff in this case, is that correct?
Correct.
The time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, ma'am.
And of Monroe County for at least 10 days?
Yes, ma'am.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes, ma'am.
To your knowledge, is Ms. Duschl pregnant?
No.
And you have no minor children, either born to or adopted by you and Ms. Duschl, is that correct?
Correct.
And did you hear the settlement agreement as I stated it on the record and as it was clarified by Ms. Kuhn?
Yes, ma'am.
Did you understand all of those terms?
Yes, ma'am.
And did we correctly state the agreement that you've agreed to today or entered into today?
Yes, we have.
All right. Do you have any questions about it?
I do not.
Have you had enough time to think about all of these issues?
Yes, ma'am.
And have I answered all of your questions?
Yes, you have.
Right. Spousal support is barred as to both you and Ms. Duschl. You understand that?
Yes.
And that means neither one of you could come into court in the future and ask for spousal support, no matter the change of circumstances.
Correct.
All right. Are you satisfied with my services on your behalf?
Yes, I am.
You understand by entering into the settlement agreement that you are waiving your right to a trial?
Yes, ma'am.
If you'd had a trial, you might have done better, worse, or the judge could have ordered substantially the same as what you've agreed to today. You understand that?
Yes, ma'am.
Are you asking the court to incorporate the settlement agreement into a judgment of divorce and grant you a divorce? Hopefully we can get him the judgment today.
Yes, I am.
Okay. Thank you. I have nothing further.
Thank you, Ms. Hills. Ms. Kuhn, do you have any questions first for Mr. Duschl?
Yes. Sir, is it true that the parties were married on September 21st, 2019 in Toledo, Lucas County, Ohio?
Yes.
Okay. Have you made a full disclosure of all assets and debts?
Yes, I have.
I don't have any other questions.
Thank you, Ms. Kuhn. Questions for Ms. Duschl, please.
Yes. Melly, can you state your full name for the record?
Molly Brunnis-Horanek Duschl.
Melly, you heard the agreement that was read on the record, correct?
Yes.
You also heard your husband's testimony as to the fact that he resided in the state of Michigan, that you were married on September 21st, 2019, and that you were not pregnant.
That is correct.
He also stated that there were no children born of the marriage, correct?
Correct.
Okay. With regard to the terms and conditions that were read onto the record, you understand that spousal support has been forever barred as to both you and your husband.
Yes.
You understand it means that you nor he can ever come back in the future requesting a word of spousal support.
Yes.
You also understand that with regard to the retirement division, that you both have agreed, despite having any type of valuation on the pension or knowing what amount of money in your 401k was premarital, you both have agreed that you're each going to be awarded your own retirement accounts.
Correct.
And you understand that Ms. Hills nor I can tell either of you whether or not that is, if that's a fair offset, given that there were no valuations done, correct?
Correct.
But despite that, that is your agreement and that's what you want, correct?
Yes.
And did I give you an opportunity to think about maybe heavy valuations?
Yes.
Okay. With regard to all the other terms and conditions of the agreement, you understand that there are things that are expected of both of you that need to get done with regard to the division of bank accounts, closing accounts, removing your name from accounts, continued payment of utilities and the mortgage until the house sells. You understand all of those terms and conditions, correct?
Correct.
Do you have any questions of either myself or of the court regarding any of what was placed on the record?
No.
And have you had enough time to think about everything?
Yes.
Is it true that you and I met prior to today to discuss what possible resolutions would be acceptable?
Yes.
And you understand that had we gone to a final hearing in this matter, the result could have been better, could have been worse, or substantially the same.
Yes.
And notwithstanding that fact, you were asking the court to adopt the agreement that was placed on the record and to grant the complaint for divorce.
Correct.
Are you satisfied with my advice and counsel?
Yes.
Has anyone threatened you, coerced you, or otherwise induced you to enter into this agreement?
No.
You're doing this of your own free will.
Correct.
No further questions.
Thank you, Ms. Coon. Ms. Sills, do you have any questions of Ms. Duschl?
No, Your Honor, thank you.
Ms. Duschl, the court had one question. You acknowledged your husband's testimony, his belief that you were not now pregnant. Can you please verify that you are not now pregnant?
I am not now pregnant.
Thank you. Ms. Sills, you'll prepare the judgment?
I will. Thank you.
Well, the court would like to thank and acknowledge Mr. Pratt for her assistance in facilitating resolution, as well as, of course, Attorney Sills and Coon for helping facilitate ample resolution. The court would applaud you, Ms. Duschl, for reaching your own agreement. Without question, the best resolution of a case of this nature is one which you both participate, as you have this morning. And the court applauds you for that. Based upon the testimony that's been presented this morning, as well as the plaintiff in this case, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be, unfortunately, no chance of reconciliation. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved. The judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That will conclude the hearing. Have the rest of the day.
Thanks,
Thanks,
Judge.
Your
Thank you.
Okay, so welcome.
Court is now in session. Scott Salak versus Lindy Joanne Salak.
For the record, this matter is before the court for a continued pretrial conference. Subsequent to the parties having engaged in mediation this morning with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Eric Pasner representing the plaintiff Scott Salak. Mr. Salak is present. In addition, Attorney Anthony Brusco is present representing the defendant Lindy Salak, and Ms. Salak appears to be present with Mr. Brusco. Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon, Judge.
The court appreciates everyone coming back this afternoon. I had an obligation at noon. Were the parties able to reach their own agreement this afternoon?
We have, Your Honor.
Yes, Judge.
Wonderful. Who would like to place that agreement on the record?
Either one of us, I can do it.
Please. Mr.
Yeah, go ahead, Eric. I'll keep track.
Yeah, let me know all my mistakes. Judge, the parties are parents to two minor children. As far as custody is concerned, they're going to be sharing joint physical custodial rights to the two minor children. Mr. Brusco and I will agree to specific language regarding a definition of joint legal custodial rights, which will also be incorporated into the judgment of divorce. As far as parenting time is concerned, the defendant mom will exercise parenting time each and every Monday and Tuesday overnight. The plaintiff father will exercise parenting time each and every Wednesday and Thursday overnight. Parties shall alternate weekends, Friday through Monday. Parties will alternate holidays pursuant to the Monroe County front of the court alternate holiday schedule. And for the summer parenting time, the parties will exercise a week on and week off parenting time schedule. The issue of child support is going to be reserved based upon the equal parenting time between the parties, as well as the close proximity of their incomes. Anything that's not covered by insurance would be shared equally between the parties, and there'll be no ordinary medical expense due to the fact that no child support is being paid. Additionally, no spousal support should be awarded to either party, and any claim either party may have shall be forever barred. With respect to the taxes and tax dependency, the child tax credit, each party shall claim one minor child as a tax dependency exemption, as well as the child tax credit. When one child remains, the party shall alternate claiming that child, with the plaintiff claiming the child in even years and the defendant claiming the minor child in odd years. Additionally, with respect to extracurricular activities, the children are currently involved in basketball, volleyball, and softball. They will continue to engage in those activities. Any additional activities will be pursuant to the parties' joint legal custodial rights, and they will have conversations and discussions ahead of time, coming to an agreement in advance in writing, and the cost for those activities, in addition to the ones that the kids are currently participating in, shall be shared equally between the parties. With respect to the household furniture and furnishings, specifically, the plaintiff will be retaining the master bedroom furniture set, a wall clock, one TV, one of the kids' dressers, one recliner, the liquor cabinet, and all of his premarital property. The balance of the household furniture and furnishings should be split pursuant to agreement between the parties. In the event they are unable to resolve that issue by the end of June, which will be submitted to Mr. Godfrey before the end of June. If this is not submitted to Mr. Godfrey in a resolution prior to the end of June, then the parties waive their right to any claim for that personal property. As it relates to the retirement accounts, Judge, the marital portion of the following retirement accounts will be shared equally between the parties, marital portion being defined from the date of marriage through March 31st of 2024, plus or minus gains or losses. Mr. Breskel and I will agree on someone to prepare the qualified domestic relations orders, and those costs will be shared equally between the parties in addition to any administrative fees charged by the plan. Specifically, the marital accounts consist of the plaintiff's TIAA CREF 401k from Mississippi State, in addition to his TIAA CREF 401k from Stetson University, as well as the defendant's TIAA CREF 401k. And again, the goal will be try to minimize the number of quadros that are going to be necessary in order to effectuate that distribution. The plaintiff shall retain in its entirety the following premarital retirement accounts: his TIAA CREF 401k from Princeton University, his second TIAA CREF 401k from Princeton University, his TIAA CREF 401k from Dartmouth College, in addition to the second TIAA CREF 401k from Dartmouth College, as well as his Oakmark Roth IRA. Again, those will be retained exclusively by the plaintiff. With respect to the vehicles, the plaintiff shall retain his 2019 Ford F-150. The defendant shall retain the 2002 Ford Bronco Sport. There's a debt that's on that vehicle that's titled jointly in both parties' names. Defendant is required to make sure that she timely makes the payments on that vehicle, pays for the insurance, license, and tabs on that vehicle. In the event that she misses 2 payments, and that vehicle is to be returned back to the plaintiff, and he can dispose of it as he chooses. With respect to the parties' bank accounts, other than plaintiffs, American Express high yield savings account, each party shall retain their respective bank accounts free and clear of any right, claim, or interest of the parties of the other party. The plaintiff's American Express high yield savings account of approximately $32,000 shall be equally split between the parties effective as of today's date. That would be through either an electronic transfer or a check written by the plaintiff to the defendant. As it relates to the kids' 529 plans, those will continue to be maintained for the benefit. There is a business that is called Glove Last. With respect to that business, the defendant is awarded 1/2 interest in plaintiff's current interest in that company with a valuation date of March 31st of 2024. Only in the event that the plaintiff sells his interest would defendant receive her 50% interest of plaintiff's interest in that business if any payment is made at all. From either when a payment is made or no payment made upon sale of that interest, the defendant would have 90 days to conduct any audit that she chooses at her expense in order to verify the value of the business as of March 30, or that value, I should say, of plaintiff's interest in that business as of March 31st of 2024. There will also be a one-time cash payment made from the plaintiff to defendant in the amount of $1,550, and that will be made within 30 days of today's date. I believe that is the totality of what the agreement is, but I defer to Mr. Breskel if I've missed something.
Thank you, Mr. Pasner. Mr. Breskel.
Did you hear everything? Yeah. Okay. That is the totality of our agreement. Friendly amendments was as a 2022 Bronco, not 2002. And I just wanted to make clear with the court that the parties have until the end of June to submit a request for binding arbitration to Mr. Godfrey if they can't resolve their personal property issues other than the specific awards that have already been made to plaintiff.
And if they do not make a request for binding arbitration with Godfrey, then each will keep the personal property they have in their respective possession. There's no longer any dispute or issue about personal property division, correct?
That is correct, Your Honor. They'd waive any further claims.
That is correct, Your Honor.
Very well. Thank you, Mr. Pasner, Mr. Breskel. Mr. Salak, will you both please raise your right hand to be sworn?
I do.
Thank you. And Mr. Pasner, you can be with Mr. Salak. The court would note we did take the proofs back on January 22nd. Mr. Breskel can simply update the proofs to confirm Mrs. Salak is not now pregnant. Otherwise, we can just proceed with award during your client with respect to the agreement, please.
Thank you, Your Honor.
Sure.
Mr. Salak, you heard the agreement that was placed on the record this afternoon based upon our 2 mediation sessions with Mr. Walker.
Yes.
And you understand those terms and provisions?
Yes.
And you're willing to be bound by those terms and provisions?
Yes.
And you understand that you could have proceeded to trial before this honorable court where you may have received a more favorable, less favorable, or the result that you've agreed to at mediation, and you're waiving your right to trial and want the court to accept this as a full, final, and binding resolution upon presentation and the consent judgment of divorce.
Yes.
I have no further questions, Your Honor.
Thank you, Mr. Pastor. Mr. Breslow, do you have any questions first of all for Mr. Salak?
Briefly, Your Honor. Mr. Salak, have you accurately and truthfully disclosed all of your assets in this world during the course of these divorce proceedings, whether in mediation or just through your attorney and your verified statements?
Yes,
Have you've not concealed or hidden anything and kept it from the division of from being divided by this court?
no, not that I'm aware of, no. Everything I said is true.
Okay. There's been some conversation about a limited liability company named Glovelast. You've accurately disclosed your interest in that company, and you've not done anything to conceal any interest in that company?
Well, the information I gave you was correct. I was wrong about the percentage about Mr. Pazza this morning. It was 5%. Like I previously stated, I have not done anything with that company, no.
Okay. Thank you, Your Honor. That's all.
Questions for Ms. Salak, please, Mr. Breslow?
Thank you, Your Honor. Lenny, can you confirm, are you presently pregnant?
No.
Okay. You've heard the agreement that has been placed on the record and has been lengthily negotiated over the course of 2 mediation sessions, correct?
Yes.
Is this the property settlement agreement that you're asking this court to adopt?
Yes.
You understand that we could have proceeded towards a contested trial. You could have done better. You could have done worse. You could have done exactly the same, but instead you're asking the court to adopt this as your agreement?
Yes.
You've heard the provisions regarding spousal support. This court is going to bar spousal support to both you and Mr. Salak, and you're never going to be able to come back and ask for that. Do you understand that?
Yes.
And are you okay with that?
Yes.
Okay. You heard all the provisions regarding the minor children, the custody and parenting time, and everything going along with that, correct?
Correct.
Do you believe those to be in the best interest of your girls?
Yes.
All right. And you're asking the court to order those as the custody and parenting time provisions in this case?
Yes.
Have you hidden anything from Scott, or have you failed to disclose anything from Scott?
No.
Okay. Are you satisfied with my representation?
Yes.
Okay. Judge, I have nothing further for Mrs. Salak.
Thank you, Mr. Breslow. Mr. Pastor, do you have any questions of Ms. Salak?
Yes, Your Honor. Mrs. Salak, you again have fully, completely, and accurately disclosed all of your assets and liabilities pertaining to the marital estate.
Yes.
And during the course of your marriage and prior to filing for divorce and during the pendency of these divorce proceedings, you have not transferred or have any third parties holding any assets on your behalf that you have excluded from the marital estate?
No.
Okay, I have no further questions, Your Honor.
Thank you, Mr. Pastor. Mr. Pastor, you'll prepare the judgment, is that correct?
Yes, I will, Your Honor.
Thank you. The court would like to thank and acknowledge Mr. Walker for his assistance this morning, and the court would also acknowledge, of course, Attorneys Pasner and Driscoll for helping to facilitate amicable resolution. The court would applaud you, Mr. Salak, for reaching your own agreement. Without question, the best resolution matters of this nature is one which you both participate, helping agree upon. Far better off than having the court decide these matters. Keep in mind, you will not be divorced until the court signs written judgment. Hopefully that'll be within the next 3 weeks, next 30 days. In any event, based upon the testimony that's been presented this afternoon and previously, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the object of matrimony has been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. According upon receiving the consent judgment, the court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce from bonds of matrimony. Good luck to both of you. That will conclude this proceeding. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor. I appreciate it.
Thank you, Your Honor.
Now stating the LGAL's recommendation.
The LGAL is recommending dad's parenting time be suspended at this time. I'm recommending that the children be returned to mom today at 6 p.m. She keeps them through dad's weekend to make up for the time that he had them when he wasn't supposed to have them, and that they go back to dad for their dad's weekend on April 12th. Nobody agrees with my recommendation.
Okay. That's sort of what I hadn't thought, but the other thing, and then before the parties come in, I'm going to award joint legal custody so that the dad cannot authorize a medical treatment without mother's approval and consent.
That would be probably a good idea, Your Honor.
There was an order back in 2020 when dad had the sole decision-making authority as to medical decisions. But that was when mother had very limited parenting time. Since then, It's a change, but we never changed that. And I thought mother should be involved in those things rather than dad just going off to the hospital. So I'm just going to unilaterally modify that.
Okay. All right.
So you can listen in. We'll add that the
Yes.
probably should share. They right now they have joint legal, but the prior order just said the father plaintiff had sole decision making. So I'm going to modify that to indicate the parties shall jointly share authority for medical and educational decisions. or medical, primarily just medical. It's not confuse things or with education, but just some medical at this time. So he can't take the job. But some of these allegations are just simply almost like preposterous. And I've reviewed all the medical reports.
Mhm. Yeah, I looked at them, Your Honor. So the parties will have joint legal authority regarding medical decisions.
Correct. Yeah.
I
Of
added
course,
that.
both parties filed joint ex partes, and I said, no, I'm not going to. Let's just set it for emergency hearing today.
Correct.
And I'm going to deny both. I'm inclined to deny both motions.
Do you want me to put that in the rec too, or you want me to wait till we get on the record?
That's what I was planning to do, is give mom make up attorney time and then get back things to the way they were, but require joint authority on medical treatment.
Okay. All right, I'll bring them out, Your Honor.
Thanks for your help.
Dunn versus Sarah Dunn.
For the record, this matter is before the court for an emergency hearing earlier this week. This hearing is being conducted via Zoom, I should say. First of all, present our attorney Christina Hills, representing the plaintiff father Kevin Dom, and Mr. Dom is present. In addition, attorneys Kimberly Kuhn and Lauren Zahner are present, representing defendant mother Sarah Dom, and Ms. Dom is present. In addition, Garnett Lightham, Amber Billmeyer is present. Good afternoon, everyone.
Good afternoon.
Earlier this week, the court received, actually on the same day, earlier this week, motions for ex parte relief from both plaintiff father and defendant mother's counsel, each wanting to suspend the other parent's parenting time. In addition, the court reviewed those motions, did not want to address them until the court could hear from both sides. The court is also in receipt of medical reports that have been submitted sealed for the court's review from ProMedica Hospital relative to allegations made by the plaintiff father on behalf of the minor child Kevin, 5-year-old Kevin, alleging that he had sustained some rectal injuries, suggesting to medical personnel that mother was the suspect for causing this injury. But in any event, the court has reviewed all that. The parties have conferred with Ms. Patrick in front of the court this afternoon. Ms. Patrick has provided the following recommendation, which I'll share with everyone, then I'll hear from everyone. Ms. Patrick has recommended that the minor children be returned to defendant mother today at 6 p.m. For that, defendant mother shall have make-up parenting time April 5th, 6th, and 7th, 2024 as make-up parenting time. Commencing April 12th, which is a week from Friday. Father will commence his previously court-ordered parenting time for weekends. It's noted that the guardian ad litem, Mr. Bellmeyer, is recommending that plaintiff father's parenting time be suspended. So this is a recommendation made, noting the position of Mr. Bellmeyer. That is a recommendation. Ms. Hills, response on behalf of your client?
With regard to the recommendation, my client is still requesting that his motion be granted and that mother's motion be denied.
Right.
Would you like to hear
Ms.
argument
Kuhn?
from me at this point, or hear from Ms. Kuhn first?
Oh, we'll hear from the other side, then I'll hear argument to Ms. Kuhn or Mr. Zinner, who wants to speak on behalf of Ms. Dom.
Your Honor, we're requesting that our motion be granted and that plaintiff's motion be denied.
Okay. Ms. Billmeyer, you are recommending, after having reviewed the pleadings and medical reports, that dad's parenting time be suspended. Is that correct?
That's correct, Your Honor. If you recall, my recommendation from the start was a 6-month suspension of father's time because my concern was that this was going to happen over and over and over again. And I just want to point out that it has.
In terms of father making the allegations that the mother is abusing the children physically?
That's correct.
Okay.
And if you recall, Your Honor, there was a report after forensic interviews were done of the children, that indicated there was that they believed the children were being brainwashed by grandmother and father to make these absurdly wild accusations.
Thank you for refreshing the court's memory. And if the court, perhaps you could correct the court if I'm wrong, is there not an order in place right now that prohibits contact between the paternal grandmother and the children?
There is a court order, yes. That part of it's taken care of.
Okay, all right, thank you. All right, argument, Ms. Ellis?
Thank you, Your Honor. At this point in time, Your Honor, we have an open CPS investigation regarding these allegations in both Ohio and in Monroe County. Amber McFall is the CPS worker who has been assigned here in Monroe. I know the court has reviewed the motions. I do not intend to belabor any of the contents of the motion. I would just point to the medical records from Toledo and indicate that their differential diagnosis, it states, includes but is not limited to abuse, and that the doctor noted that there was shallow rectal tearing. Tearing is the word that was used, with no active bleeding, and the child tolerated the exam well. There was a SANE exam done at Toledo Hospital. We do not have the results of that yet. There is a Toledo Police Department investigation. I provided the case number for that in the motion. I do not believe my client has had contact with any investigator in that case as of yet, but we have multiple open investigations as to the allegations in this case at this point. There have been multiple unexplained injuries to the children, bites, scratches, bruises. My client has asked mother for an explanation for those injuries. She has not provided him any explanation as to how the kids got those injuries. Mr. Haskins, in his most recent letter, seems to explain that the children roughhoused together in his office a lot. So he offers an explanation, but my client can't seem to get one from mother. Mr. Dom is being painted as an alienator. I think that's far too simple and easy a fix to this, if you want to call it that. There definitely needs to be a deeper look as to why these kids are saying these very disturbing things that they're saying to my client about what is happening at mother's house. Whether they are true or not true, the fact that they're saying them to dad is very alarming. And to ask him not to act on those things, I do not believe that is fair at all. He took the children to the doctor, the emergency department at ProMedica, which I advised him to do after he advised me what the allegations were. He also let Ms. Billmeyer know what the allegations were at the time. He informed mother what he was going to be doing with regard to taking the kids to the emergency department. When faced with children who are corroborating each other's stories as to what allegedly happened, and combining that with bleeding from the rectum, he had no choice but to do what he did. If he didn't do that, ultimately, if there is abuse happening and he's determined not to be protecting these children, then he could lose his parental rights for not taking action. Mr. Haskins, in his letter, which I don't know if the court has seen or not, simply says that he doesn't find the statements that are made by Kevin and Noah to be credible, but he doesn't say they're not making them. Again, we need to get to the bottom of why the kids are saying these things. If they're acting completely differently with mother, why are they acting so completely differently with mother and father? My client tells me he is in no way coaching these children, brainwashing them, but somehow they're coming up with these outlandish sounding allegations. But again, if my client doesn't act on those, if he simply says to the kids, sit down and be quiet, these things can't possibly be true. These children who have PTSD and have been traumatized in the past are now being traumatized again by having their statements and their feelings being invalidated by the person who's supposed to be there fighting for them and protecting them. So I'm also concerned Mr. Haskins has completely cut my client out of any sort of contact with him at this point. We had agreed last time we were in front of the court that I would be able to get the information in writing from my client and pass that along to Mr. Haskins. My client put together a very thoughtful report passed it along to me. I forwarded it to Mr. Haskins probably a matter of a couple of weeks ago at this point, at least a week ago. And I've not gotten so much as a thank you for the email, Ms. Hills, not any sort of indication that he's even received the email that I sent. So as far as I know, my client has no contact at all with the one person who's really charged with trying to help the children navigate this whole situation. And again, I don't think that telling the children that, oh, you're lying, stop saying those things is the right way to handle this. He did exactly the right thing by contacting the authorities. He did what the doctors did, but making a 3,200 to CPS. And frankly, he did what I believe our friend of the court would have done under the circumstances had Mr. Dom called them and said, here's what my children are saying. So I don't think he can be penalized for doing what he needs to do to protect the children. Now it's up to the authorities who are charged with investigating these sorts of things to determine and get to the bottom of what exactly is going on here. And if these things are not true, then why the children are saying them. And if they are true, then to deal with it in a way that is appropriate under the circumstances. Again, I have serious concerns about Mr. Haskins continuing on as a therapist for the reasons I've already mentioned. This letter appears to be a character reference letter for mother. He's essentially a cheerleader for mom at this point. He makes statements which are incorrect as to the timing of the incident, alleged incident, which led to the report in this case. And I do believe that he should be replaced as counselor. We could go with wraparound in Toledo. They have counselors available. We could go with another counselor, could be agreed on in Monroe, but I don't believe that Mr. Haskins has the objectivity or the ability to continue on and help these children navigate this situation. So we are asking that the court suspend mother's parenting time until Toledo PD, until CPS in both locations can complete their investigations, and not penalize father for doing what he needed to do to protect his children and what any professional under the circumstances would have done, and that's make a report and let the people who do the investigations of these things do their investigations. He would again ask the court to suspend mother's parenting time rather than send the children back into a potentially abusive situation, at least until we have those reports from the authorities. We don't even have the report, if I didn't say this earlier, we don't even have the report from the SANE examination at this point, which I think is a critical piece of the puzzle here. The report used the word tearing. The doctors were aware that Kevy had diarrhea for a couple of days. There's no indication that in the records that injury was consistent with diarrhea. Tearing is the word that they use. So I think it's important, in fact, critical, that we wait for the professionals do their jobs, come to their conclusions, and for the SANE kit information to be received as well.
Thank you, Ms. Hills. Ms. Kuhn?
Yes, Your Honor. So what's really interesting in this case is that Ms. Hills argues that Mr. Dom did what he should have done. However, if the court looks closely at Mr. Dom's actions, Mr. Dom did what Mr. Dom wanted to do. And I just want you to follow my logic, Your Honor. If you look at page 2 of Ms. Hill's motion, it states that plaintiff took the child to ProMedica Monroe Hospital where testing was done. It was confirmed that a child had an injury to his anus. It also states that the child was complaining of pain. His bottom hurt when he was wiping. If you look at the ProMedica records, father stated that for the past 2 days, the minor child has had diarrhea. And if you look further into the records, it states from ProMedica that there are no obvious external signs of rectal trauma on exam, no active rectal bleeding. In fact, the child didn't even complain of any discomfort. So Mr. Dom signs this petition to suspend mother's parenting time under oath that There was injury that was confirmed by ProMedica. There was a CT scan done. It was done in Toledo. ProMedica said, hey, no obvious signs, but if you feel the need to go deeper, you're going to have to have a CT scan and a SANE exam. Father made the decision to have this child undergo yet another SANE exam. Your Honor, it's abuse to even have a child undergo one SANE exam when there's never been any substantiation of sexual abuse. In fact, the CPS allegations that Mr. Dom has made in the past alleging sexual abuse where this child has had to go undergo a SANE exam have all been unsubstantiated. So yet here's this poor kid undergoing yet a third SANE exam on Easter morning at 2:30 in the morning, Your Honor. But yet Mr. Dom knows that the child has had diarrhea for 2 days. And I'm confused as to why Mr. Dom is wiping Kevy's butt with the tissue. The child, from my understanding, is self-sufficient and wipes his own butt at mom's house. So that's a little concerning that he's doing that as well. But if you Google what the exact term for the anal tear, it states that it can occur from constipation. It can occur from wiping. A tear, a superficial tear is certainly not the injury that would be caused by a butter knife. And I'm going to let Mr. Zahner talk about that because Mr. Zahner has actually spoke in as an ex-abuse and just those issues. But as a parent, having child that has had diarrhea before, there is bleeding sometimes. So the fact that there were other plausible explanations, but Mr. Dom wanted his child to undergo a SANE exam and to undergo a CT, a full body CT, presumably to see if there were any broken bones, is just absolutely preposterous, Your Honor, on Easter morning. This is what this child was doing. If you look at past indicators, Mr. Dom is always accusing Miss Dom of abuse. In fact, the guardian ad litem mentioned that she's getting allegations every weekend that Mr. Dom has the children. My client gets these archaic messages, took the children to the doctor, everything's okay. So what's happening is these kids are going home, being subjected to a full body scan, and then being rushed off to the doctor to see if there's any abuse. Your Honor, that's abuse. We have done everything in this case, Your Honor. This court has suspended mother's parenting time. This court has supervised mother's parenting time. The one thing that we haven't done is suspend father's parenting time. These kids need help. They need to heal. We need the 6 months so that mom can get the kids the appropriate medical attention they need. Dr. Memon recommended Abilify for Noah. Father's refusing to even consider it. This child needs medication and father can't even do the right thing. The sabotaging of these children, the subjecting them to medical exams, the refusal to find any other plausible explanation for bright red superficial rectal bleeding when your butt is wiped after 2 days of diarrhea is just absolutely just beyond, it's incomprehensible to me, Your Honor. This situation, if Mr. Dom wants to continually subject his kids to this type of evasive procedures and not understand that, these kids have stated that giant microwaves have dropped from the sky in their backyard and injuries have occurred because monsters have come out of microwaves. Some of the allegations, all of the allegations so far, there's been no allegation that's been substantiated. CPS has been involved every time Mr. Dom makes a complaint. In fact, CPS said that Mr. Dom and his mother are coaching and brainwashing these kids. These kids need to be away from Mr. Dom. It is the only way to ensure that these kids are going to be able to heal. These kids are getting damaged every day, every SANE exam, every doctor appointment. Mr. Dom chose Mr. Haskins.
these kids actually enjoy talking to Mr. Haskins. And the reason why Mr. Dom doesn't want Mr. Haskins to work with the kids is because Mr. Haskins is saying, hey, look, there are issues here. The kids are saying things that aren't true, but Mr. Dom wants to continue believing that false narrative that Sarah Dom is a monster, that she's going to hurt her kids, that she's an abuser. Mr. Haskins doesn't subscribe to that false narrative, so he needs to go, according to Mr. Dom. That is doing a disservice to these children. Mr. Haskins is a very good therapist. He has a very good relationship with these kids. In fact, he's supposed to see these kids today. The kids have an appointment on Thursday at 4:30. I'm hoping that the kids are returned to mom so that these kids can get to their appointment with Mr. Haskins. Because you know what? When they're undergoing the things that they're undergoing, when they're having to deal with what they're dealing with, they need help. Your Honor, I would ask that you let Mr. Zahner talk about what an injury would look like if a butter knife were, and I would ask that the court also consider what the guardian ad litem has to say, who gets all of the allegations of abuse after every weekend of Mr. Dom's parenting time. I would ask that the court listen to them as well, and I would strongly urge the court, please suspend Mr. Dom's parenting time so that these kids have a shot. Thank you.
Thank you, Ms. Kuhn. Mr. Zahner?
Yes, just briefly, the court, just using common sense, you think of a 5-year-old child and a butter knife, all kinds of abrasions, there's going to be cuts, there's going to be pain. There was none of that at all in this case. And so these allegations are absolutely ridiculous and clearly false. Father's been doing things to make up allegations with these kids. We don't know what was said. Amber has seen a video because our client's been videotaping when she has these kids with Kevin sitting on his rear end. If he had been abused, that wouldn't have been happening. So there would be all kinds of physical evidence, and there's none. And Amber can tell that as well as I can. She's a nurse.
Your Honor, I'm going to object to the lawyers on the case offering what certainly feels like expert testimony without ever A, being qualified as an expert, but B, it being completely inappropriate for lawyers on the case to be providing any sort of expert analysis.
Court recognizes Mr. Zahner's opinion, of course, is years of experience and practice of law, particularly criminal cases. But if we're from Mr. Bellmeyer, thank you, Mr. Zahner.
Thank you, Judge.
Your Honor, after the allegations came out this weekend, I did not actually see them till Monday morning. I requested that mother provide me with the video recordings from the inside of her home. As you may recall, we made that a court order during the right when her parents were starting to supervise her visits, and she had some in-home visits, because my concern was that there would be continued allegations of abuse. So I've had to look at these recordings in the past as well, after father's reported more abuse when he gets the kids back. So I did happen to look at the video. I've actually watched it twice, and there's audio to it. So it was a very good video quality. It was my understanding from both the reports and Kevin's emails to me concerning the events that he believes that this occurred on Friday before the children were returned to him. There was only a short window of time where the children were actually at home before the exchange for father's parenting time was to happen. So I viewed about 55 minutes of video, and these children were well-behaved, having fun with their grandpa, who was sitting on the couch. There were periods of time where they were playing with each other, happy-go-lucky, structured environment. Mother's making sure they're getting ready to go to dad's. Kevy's in the restroom. Kevy's complaining. Door's open, by the way. Kevy's in the bathroom going, Mom, I have diarrhea. And Mom goes, I know, Kevy, I know. I hope it gets better. And then he says, I need to drink lots of water. So this is obviously a conversation that he and his mother have had about his issue with diarrhea. Door's open. Kids are coming in and out. Grandpa's sitting on the couch. Clearly, there was the short period of time that I looked, that she was actually home between work and picking up the kids from school or grandparents until the exchange happened. These kids were fine. They were absolutely perfect. and Sarah did a great job. And there were periods of time where Kevy sat on Sarah's couch abuts her kitchen counter. So it's kind of easy if the kid's sitting on top of the couch to scoot onto the counter, which is obviously a hard surface. Just playing away with the cat, obviously not in pain. So I have not seen anything suspicious to support the allegations that have been made. And again, I do get, and to Kevin's benefit, because I told him I want these I want him to send me these things. But pretty much following every visit, I do get an update about a bruise, a scratch, a bite mark, etc. The other thing that concerns me, Your Honor, is these. I feel that Father, like the sheer mention to mother that he's taking the children to the ER is probably not enough, and that disturbs me greatly, because he should be giving mother, first of all, it's an emergency if you're taking a kid to the emergency room. You should be letting mother make an informed decision as to whether she should be there or not, and instead it was vague. His response to me when I asked him why that's not happening was, well, she has access to my chart as well, and that doesn't fly with me. I have concerns that these kids are being exposed to inappropriate medical exams after mom's visits all the time. So apparently we're padding the record. The continued abuse allegations, which I cautioned this court with both in my report and every time we've been in a pretrial, that this just continues to happen. So I have, from the start in my first report, recommended a 6-month suspension of father's time in order to let things cool off. And I still support that. We do have another issue, Your Honor, if I can just talk a couple more minutes. The child has been assessed by psychiatry, Dr. Memon, and Dr. Memon has suggested that there could be a medication that would assist Noah with his rage issues and emotional lability. And that medication is called Abilify. At first, I believe Father was on board with that. Father is medical decision-making authority, although I do believe this court gave me the authority at the last pretrial to make that decision. There's still a lot of hesitation by Dr. Memon because he's getting calls questioning whether this is actually appropriate. And I understand that Christina needs to do her job, but he's obviously getting spooked because I'm calling to talk to him about the concerns being raised about whether or not he should start it. And the attorneys are calling. Now Dr. Memon has to consult with his legal team before he even speaks to me or makes a decision. We're probably going to lose this psychiatrist. But in any event, it's April 4th. This child has got severe issues in school, and we have this opportunity right now to see if this medication is going to assist him, yet it hasn't been started because both parents can't agree. So I have concerns about that. And I
Thank you, Ms. Billmeyer.
I've covered everything.
Thank you.
Your Honor, may I respond to some of those things?
Briefly?
Thank you. As Ms. Billmeyer knows, my client and I have an appointment to speak with her via Zoom tomorrow. Medication was certainly going to be one of the topics of conversation. Dr. Memon did not recommend a medication, which was the language that our court order used. He said that the parents needed to agree, and if the parents agreed to put Noah on medication, that Abilify is what he would suggest. My client has concerns about side effects of that medication, one of which, as I understand it, is a pretty serious progressive motor disorder, movement disorder, which can even include involuntary movements. And so he would like to take a little bit of time and consider this and look at whether there are alternatives which might not carry so many side effects. I did have what I thought was a very amicable conversation with Dr. Memon, who I have a little bit of history with, and that's what he clarified. So the parents do need to decide, and if they're unable to, then the court can do with that what it wishes, set an evidentiary hearing or simply make a decision. My client did everything that was recommended by the doctors. The doctors at ProMedica recommended the same exam. They recommended the CT scan. Everything else that he did was doctor driven at that time. And I believe there's only been one prior SANE exam. I'm not aware that there have been 2 prior SANE exams. The reason he was wiping the child is because the child had diarrhea. He wasn't convinced that the child was able to make sure he got himself clean at his age. So my client's being diligent and making sure that the child is clean after a bout of diarrhea. Again, I don't think this is a situation where my client should be punished by losing time completely with his children for making a report that any of the professionals would have, and in fact did make under the circumstances. And as I'm glad Ms. Billmeyer indicated that she did, my client was kind of reprimanded previously for not informing her of claims that the children were making. So I'm glad she indicated then that she did ask him to do that. And he's reporting things that they're telling him. I'm not sitting here telling you, and I don't think my client would sit here and tell you that everything that the children are saying is in fact 100% factual. They are saying these things, however, and that's again what we need to get to the bottom of. Why such a difference between dad's and mom's house, and what's going on in these little guys' heads?
All right, thank you.
Your Honor, may I respond just quickly?
Very briefly.
Your Honor, the problem is Mr. Dom is picking and choosing what he wants to believe. And as I stated, if you look at the ProMedica report, ProMedica didn't say, go have a SANE exam and go do a CT scan. They stated, discussed with Kevin, that if there's concern for rectal injury, a CT scan and a SANE exam, they would need to proceed with further workup. So no, that is absolutely not true that the hospital said, you need to do this. They left it on Kevin Dom, and Kevin Dom is picking and choosing what he wishes to believe. Again, Your Honor, the guardian ad litem is recommending it. We're asking, Your Honor, his parenting time has never been suspended, not asking to punish him, Your Honor, just asking to take out what we believe is creating issues for this child. We're also asking that the court order that this child be permitted to try this medication. There are many children on Abilify. They actually start children on Abilify at age 6. And it can help with rage, explosive anger disorder. And this child is having big problems. Why wouldn't we try something to see if it's going to help this child and make a big difference in this child's education and social world and his self-esteem? Thank you.
Thank you. With respect to the medication of Abilify, if the parties cannot, the 2 parents cannot agree to administer the medication, the court would schedule an evidentiary hearing. I appreciate the analysis and involvement of Ms. Billmeyer. With respect to Mr. Haskins, the court will not remove Mr. Haskins from his involvement in this case. If the court recalls, and I did not receive, Ms. Hills, the last letter from Mr. Haskins, it didn't come to the court's attention. But if the court recalls, it was the plaintiff father that created that conflict with Mr. Haskins and caused Mr. Haskins to indicate he was no longer going to communicate with Mr. Dom because he is not cooperating in the best interest of the children. That's court's recollection. So whatever, court's not going to remove Mr. Haskins as a counselor for these children. With respect to, the court cannot ignore the fact that the medical reports indicate that the plaintiff father, upon presenting the minor child, Kevin, to the emergency room, he didn't just complain of rectal bleeding or that the child complained of pain. His complaint was he suspected that mother abused the child by inserting a butter knife, 5-year-old child. That's a shocking allegation. The court cannot believe that any mother would do that to a 5-year-old child. The medical reports confirm that the child had diarrhea. The reports do not seem to suggest any significant, any terror. If there was any even suggestion of a terror, perhaps it was caused by the child straining. I don't know, but there's certainly nothing that convinces this court that there was an intentional insertion of a butter knife. And the court's concerned, why he just wouldn't tell the medical professionals, well, my son has some bleeding from the rectum, he's complaining of pain. have them examine that rather than suggesting this was the cause, that mother was the cause of this. At this point in time, the court will deny the motions of both parents to suspend the other parent's parenting time. The court gives great deference to the opinion and recommendation of Ms. Billmeyer. The court recognizes she has an education and experience in the medical field as a nurse. And Ms. Billmeyer, the court greatly appreciates your continued assistance with this matter. But suspending dad's parenting time, I'm concerned. How do we then repair the relationship between dad and the child? But if this continues, that obviously is certainly the court will do that if we have continued to have these outrageous allegations and unnecessary treatment. Ms. Kuhn, is your client just asking what 3 days of makeup parenting time?
Yes, Your Honor. My client would ask to pick up the children immediately after we're done with court so that she can get them to their counselor. There's an actual counselor appointment today.
Right. Well, it's 3:45 right now, so the court will order that the minor children be returned to defendant mother forthwith. If we could keep that appointment with Mr. Haskins today, that would be wonderful. Mr. Dom, can you take the children to Mr. Haskins' office at 4:30 today?
Yes, whatever the court needs.
Yes, so ordered. So ordered to return the children, deliver the children to Mr. Haskins' office at 4:30 today. The children will be with mother this coming weekend, April 5th, 6th, and 7th. 2024 is make a parenting time. Dad's parenting time will resume April 12th, a week from Friday. The court also, and finally, the court notes that there was consent order entered in 2020, in which the plaintiff father had sole decision-making authority relative to medical and educational decisions. The court's going to modify that. That was at a time in 2020 when mother had limited parenting time. Mother has significant parenting time right now. So the court believes that any medical decision should be made jointly by the parties. So Mr. Dom, you don't, if in fact you're taking children to the emergency room, you need to notify mom immediately before you begin that transport. Let mom know exactly why you're taking them and where. And no medical procedures shall be performed without the consent of mother, the joint consent. If you can't agree, then Ms. Billmeyer will make that decision.
Yes, sir.
If it's an emergency medical decision to be cannot agree, Ms. Billmeyer will make that decision. The Bill is not an emergency decision, so if the parents cannot agree, the court will schedule an evidentiary hearing on that limited issue alone. We'll take brief testimony from Dr. Memon and Ms. Billmeyer, perhaps. But from this point forward, the court will order that the parties share equally any decisions relative to medical treatment. And hopefully that will eliminate putting these children through these types of exams that we have here. Is there anything else that the court needs to address this afternoon? Ms. Hills, Ms. Kuhn, Mr. Zahner?
No, Your Honor.
Your Honor, I just want to make sure that we don't run into the situation. We've had issues before where Mr. Dom just basically says, well, the kids don't want to come. The kids aren't going to get out of the car. I don't want to have an issue today where we have a repeat of that, since we seem to repeat a lot of our narratives. So I just want to make sure that the kids are going to be delivered to Mr. Haskins' office, that they will be out of the car, and that Mr. Dom will then leave once the kids are delivered to Mr. Haskins.
That sounds like it's the court's order, and my client will follow the court's order.
Yes.
Thank you, Ms. Hills. If the court would expect that, if not, obviously Mr. Dom is jeopardizing his parenting time. So the court will expect that the children will be delivered to Mr. Haskins at 4:30. Ms. Dom, you may want to notify Mr. Haskins that the children will be there for their scheduled appointment this afternoon at 4:30, so that can all happen.
Judge, if I may throw in one thing. If I recall last time with the medical decisions concerning any prescription medication, the court, I believe, had said if the parents cannot agree, the guardian was able to make that decision, so we didn't have to waste court's time to have hearing. So
well, any emergency medical decision, Mr. Zahner, the court would authorize Ms. Billmeyer to do that. But if in fact this medication vilify it's not an emergency, and the court would be willing to entertain an evidentiary hearing on that. It should not be a lengthy hearing. But any
Okay.
medical treatment decision parties cannot agree upon, and Ms. Bearmark can make that decision because obviously that's an emergency. So Ms. Patrick, you can just add to your recommendation that the parties, the priority of this court is modified so that the plaintiff and defendant, both parents shall have equal authority, should share equally any decision for medical treatment decisions. And with that addition, this recommendation, the court will, I will conclude this matter.
Thank you, Your Honor.
Thank you, Judge.
Thanks, Judge.
All right, everyone can zoom out. Thank you again, Ms. Bellmeyer. The court greatly appreciates your time and attention to this challenging case.